Welcome to this essential lecture on intellectual property rights, a foundational topic in research methodology. As university students and future researchers, you will spend years generating new ideas, writing papers, and perhaps even inventing new technologies. But how do you protect these invisible creations? Today, we will explore exactly how the law safeguards your hard work and how you can be financially rewarded for your intellectual contributions. To understand why we need these rights, let us start with a simple comparison. Imagine you spend months building a beautiful custom wooden chair in your garage. Because you physically built it from raw materials, you naturally own it. No one can take it without your permission. But what if you spend months writing a brilliant story, composing a song, or designing a brand new type of engine? These are creations of your mind. They are not physical objects you can easily lock inside a safe. This brings us to a critical question. How do you prove you own an idea? And how do you stop others from stealing it? This challenge of protecting invisible ideas is exactly where intellectual property rights come into play. Think of IPR as a legal lock and key for the creations of your mind. When you invent something new, write a research paper, or design a unique product, the law recognizes your intellectual effort. It gives you exclusive rights to use and control that creation. For a certain period of time, nobody else is allowed to copy, manufacture, or sell your work without your explicit permission. By legally registering your intellectual property, you transform an invisible idea into a recognized, protected asset. Now that we know what these rights are, let us look at how they appear in the real world, especially in academia. Intellectual property rights usually take three main forms. First, we have patents, which are used to protect physical inventions and new technologies, like a new medical device. Second, we have copyrights. These protect written and artistic work, which includes your research papers, thesis documents, and published books. Finally, we have trademarks, which protect brand identities. By utilizing these different forms of IPR, researchers can control, share, or even sell their ideas, just like they would sell a physical piece of property. Understanding the types of protection leads us to why this system is so absolutely essential. Without intellectual property rights, the world of research and innovation would completely collapse. Imagine if anyone could freely steal a scientist's new medical drug or a writer's new book. Creators would have absolutely no motivation to spend years researching and developing new things. IPR ensures that researchers are financially rewarded for their hard work. Furthermore, it protects the integrity of academic work by legally defining what constitutes plagiarism and intellectual theft. Ultimately, these rights foster a healthy environment where society benefits from continuous innovation. This financial reward we just mentioned brings us to the concept of commercialization. While intellectual property rights are primarily a legal concept, they have a direct mathematical translation when it comes to earning money. When a researcher allows a company to manufacture or sell their intellectual property, they usually charge a usage fee. This fee is called a royalty. Royalties are the vital link between your legal rights and actual commercial revenue. They form the backbone of how inventors, authors, and researchers make a sustainable living from their protected ideas, allowing them to fund even more groundbreaking research. To understand exactly how these earnings are calculated, let us look at the standard financial formula for royalties. The formula is R equals P times R times N. Conceptually, this simply multiplies the profit per item by the total items sold. Let us break down every symbol. R represents the total royalty income earned by the creator, measured in a currency like dollars. P stands for the retail price, or revenue generated by a single unit, like one book. The symbol R represents the royalty rate, which is the percentage of the price that goes directly to the creator. Finally, N represents the total number of units sold. If the royalty rate R increases, the creator takes home a larger slice of the profit per item. If the number of units sold, N, increases, the total royalty R grows proportionally. Before we move on, let us see this formula in action with a concrete example. Imagine a university professor publishes a textbook on research methodology. We are given that the retail price, P, is $100. The publisher offers a royalty rate of 15%, which we convert to a decimal, making R equal to 0.15. We are asked to find the total royalty if N equals 2,000 copies are sold. We chose our standard royalty formula because it directly connects these variables. First, we substitute our known values. We multiply the $100 price by the 0.15 rate, which tells us the professor earns exactly $15 for every single book sold. Next, we multiply this $15 cut by the 2,000 books sold. This gives us a final answer of $30,000. Physically, this means the copyright has translated the professor's academic research into a $30,000 financial reward for their first year of sales. Now that we have calculated a copyright royalty, let us consider a more complex scenario involving a patent. A biomedical researcher patents a new heart monitor. A manufacturing company sells each monitor for a price P of $5,000. The royalty rate R is 4%, or 0.04. In the first quarter, they sell N equals 350 units. We need to determine the researcher's total financial compensation. Again, we use our royalty formula. We plug in 5,000 for P, 0.04 for R, and 350 for N. First, we multiply 5,000 by 0.04, which yields $200. This is the researcher's cut for every single device sold, acknowledging their foundational invention. We then multiply this $200 cut by the 350 units sold. The final answer is $70,000. This substantial income demonstrates the immense real-world value of securing a patent, allowing the inventor to be fairly compensated while a larger company handles the heavy manufacturing. These two examples perfectly illustrate a broader process, which we can now visualize in this flowchart. Let us walk through what you are seeing on screen. On the far left, we start with the glowing light bulb, representing your original idea or academic research. Notice the arrow pointing to the center shield. This shield represents the crucial step of securing your intellectual property rights, whether through a patent or a copyright. This legal protection acts as a secure hub. From this shield, the path splits into two parallel outcomes. The top arrow leads to a factory, representing the commercialization and manufacturing of your idea by a larger company. The bottom arrow leads to a money bag, representing the royalties and grants that flow back to you, the creator. This diagram teaches us that without the central shield of IPR, the original idea can never safely reach the stages of manufacturing and financial reward. As we can see from the flowchart, this process is about much more than just individual profit. It is about fueling a continuous cycle of innovation. By providing a secure, legally protected pathway for commercialization and royalties, IPR ensures that creators have the funding they need to keep inventing. When researchers receive the respect, financial backing, and legal protection they rightfully deserve, they are motivated to tackle even bigger problems. In turn, society benefits immensely from the continuous release of new medical devices, technologies, and literature. Understanding these rights is absolutely crucial for any researcher who wants to share their work with the world while safely guarding their own professional and financial interests. We have covered a lot of ground today, so let us reinforce the most important ideas from this topic. First, remember that intellectual property rights are the essential legal mechanisms that protect the invisible creations of your mind, ensuring you retain ownership of your original ideas. Second, tools like patents and copyrights are vital for preventing unauthorized copying and academic plagiarism. Third, we learned that royalties mathematically link your legal rights to actual commercial revenue, calculated using the simple formula R equals P times R times N. Finally, always remember that by protecting creators, IPR fuels a sustainable cycle of innovation that benefits the entire world. You now have the knowledge to protect your future research and inventions. Keep innovating.